Welcome back. So, Deputy Justice Minister Andries now has conducted service delivery enhancement visits at Western Cape courts. It aims to find measures to improve efficiency. The visit comes months after a deadly shooting at Cape Town's Wynberg Magistrate's Court. So the Deputy Minister joining us now for more on this. So, DM, good evening to you. Thank you so much for your time. Important visits these. Talk to me about what led to it, certainly what prompted it, the courts that you visited, and some of your key findings.
Very good evening, and a very good evening to your listeners as well. The past 3 days I've spent in the Western Cape, in Cape Town in particular, visiting courts in Mitchell's Plain, which also happens to be my constituency, Goodwood and Wynberg. Now, I think just at the outset to clarify that the courts that I was visiting are specifically small claims courts and municipal courts. And the reason for that is that these are courts that provide access to justice to many, many South Africans at the most basic levels. And in particular, the small claims courts are incredibly, incredibly important avenues to enhance access to justice. Small claims courts are not toy courts, they are very real courts. The summons to appear before them is very real. The judgments that they give are absolutely binding. But what makes them different and so special is that they deal with claims up to 20,000 Rand. Secondly, it's up to the litigants themselves to take control of the process, to go to a clerk of the small claims court and to initiate the process. No lawyers are involved. The proceedings are conducted in the language that the applicants understand and comfortable with. The person who presides is known as a commissioner. That is either a magistrate or a legal practitioner, an experienced legal practitioner. They serve as volunteers for the love of serving their community and providing justice. They do not earn anything for rendering that service. And I must say, in the past year, we've had 38,854 small claims court cases. And I think the significant thing is that those cases involve claims worth about 254 million Rand. And I think just to indicate the effectiveness and the efficiency of those courts is that 35,000 of those 36,000 cases were finalized, involving about 245 million Rand. I visited Wynberg today, and I was very, very, very impressed with both the advisory committee on small claims courts, the commissioners, but in particular, the staff of that court, the clerks, the interpreters, so dedicated, so professional. The small claims court usually starts at about 4 in the afternoon. Sometimes it carries on until 10 or even 11 at night.
Yeah.
But those clerks, those interpreters are there. The commissioners spoke extremely, extremely highly of their dedication and professionalism.
Yeah.
I can also report that I saw firsthand the enhanced security measures at Wynberg after that terrible, terrible incident where the minister and I intervened immediately. The necessary equipment has been loaned to ensure that safety can be provided whilst more permanent measures are put in place.
Yeah, very important. And of course, we'll talk about steps to continue that work in other parts of the country, perhaps towards the end of our discussion. But really difficult to speak to you as the Deputy Minister of Justice without, of course, getting a response on that ruling coming out of the Supreme Court of Appeal that allows for a retrial of the Nulan case. I mean, it stands out, right, at a period where there's been much criticism for the National Prosecuting Authority. This perhaps somewhat of a vindication for the authority, for the perspective of the Department of Justice, what you really believe this ruling by the SCA actually means, possibly in also getting Gupta associates to face accountability in South Africa. Are we a step closer?
No, thank you very much for that very important question. We join the National Prosecuting Authority in welcoming the judgment by the Supreme Court of Appeal. I think it vindicates the position that has been held by the National Prosecuting Authority from the outset, that they do have a strong case, that case was professionally and adequately presented to court, but that it was wrongly and very wrongly decided. And I think the Supreme Court of Appeal did not mince their words in describing what really amounts to a miscarriage of justice. So we do welcome the judgment, and I think the message that it sends is that the struggle to bring those responsible for state capture to account, unfortunately, is a marathon, not a sprint. There will be progress and there will be setbacks. There will be victories and there will be defeat. But the standpoint of this government is clear and unambiguous that we are committed to hold those responsible to account, no matter how long it takes, no matter what setbacks we face, but we will pursue, we will persist until that objective is achieved.
Yeah, because what this ruling of the SCA does is it goes back to the ruling coming out of the High Court that essentially said that the documentation put forward by the National Prosecuting Authority against the accused, I mean, the word zilch being used there by the acting judge, saying that points to very little, you know, sort of evidence that is necessary to bring the accused to account. So is there perhaps some work that needs to be done?
No, I think what the Supreme Court of Appeal said was that the judge described the evidence that was put before court as zilch.
Right.
And the SCA, the Supreme Court of Appeal, was unambiguous in condemning the use of that terminology as unjuridical and, quite frankly, unacceptable, both in style as well as content.
But does it, and this is the point that I was trying to get to, does it bring any concern to the Department of Justice around what an acting judge is able to do in helping us perhaps impacting the trickle-down effect of us being able to bring a high-profile case like the Nulan matter to account?
Look, I think the starting point in this whole matter is that we are a constitutional democracy. Our constitutional democracy has a very, very well-crafted architecture of checks and balances. We have an independent judiciary. We might disagree with judgments that are made by individual judges, but we respect the system of the judiciary. We know that it has checks and balances, and I think that has been vindicated in this case. It was a case that was fundamentally wrongly decided, but we have a Supreme Court of Appeal that has rectified that.
Yeah.
Similarly, we have a National Prosecuting Authority that is independent in the making of prosecutorial decisions. Yes, the Minister of Justice and Constitutional Development is ultimately accountable for the National Prosecuting Authority, has the right to request reports from the National Director of Public Prosecutions, but we do not interfere in those decisions.
Yeah, and that being where I want to go next, if you will allow me, you say no interference in the National Prosecuting Authority, utterances made by the NDPP, then of course a backtracking on some of those around allegations of infiltration of the National Prosecuting Authority. Talk to me about how the department is dealing with the matter of, I suppose, tackling some of those challenges that are faced by the NDPP at the moment. I know that the request made by the minister for some of those extradition matters to be brought to the minister's desk. An update on that?
No, I think it would just be important to differentiate the matters there. Firstly, as I said, the National Prosecuting Authority Act is very, very clear. The Minister of Justice and Constitutional Development is ultimately responsible for the National Prosecuting Authority. But those powers are very, very clearly delineated in the Act, and they involve, amongst others, the power to request reports from the National Director of Public Prosecutions. That is important because the Minister is a democratically elected public representative that owes an accountability both to Parliament as well as to the people of South Africa, and needs that information in order to acquit herself of that responsibility. The Minister has no power whatsoever in relation to prosecutorial decisions.
Sure.
And I think it also bears pointing out that the National Director of Public Prosecutions herself, in many cases, does not have those powers. Many of those decisions, whether to prosecute or not, are taken by provincial directors of public prosecution. The National Director has the power to review certain of those decisions.
Right.
Secondly, the matter that you raise about extraditions, I wouldn't want us to conflate that, because the law, and again, the SCA has clarified it, is that the ultimate decision around decisions whether to extradite or not fall within the realm of the executive. Those are the ministers. The minister has the power to take those decisions.
Certainly.
On previous occasions, the prosecuting authority made those applications, and those were found to be illegal.
Right.
So, yes, the minister is engaging with the National Director of Public Prosecutions to see how any cases taken after that judgment can be dealt with so that they do not get nullified.
Right, and we look forward to seeing the outcomes of those interactions. Then, Deputy Minister, I've got about 10 seconds for this. You've ticked the box on seeing those small claims courts in the Western Cape. Other provinces to follow?
Indeed, very much. Both the Minister Kubai, and I have outlined a very, very clear program of engaging all aspects of our justice system, including the courts.
Right.
Earlier in this year, Minister Kubai led a visit to the Palm Ridge Court that followed complaints that we had received from members of the public, and we will continue to do so.
And we look forward to getting those reports as well. Thank you so much, Deputy Minister there for Justice and Constitutional Development, Andries now.